happening, it is not judgment, some arguments are not going properly and influence is going on, so you can ask the Supreme Court to transfer to different high courts. If you feel the judgment might not be done properly, you can go to using the certiorari petition. So this is the thing, and this is the one of the question might ask. This is the if you see that this one BEAR Act, after completion of all articles, you can see the schedules. There are initially only 8 schedules are there in 1950 whenever that constitution is enacted. So after that one, based on the amendments, there are a new four schedules has been added over here. So these are the repetitive question. One is the repetitive question. 7 is the divisional of powers. If you see 7th schedule having the concurrent union list and state list. There are 3 lists available. So one is the union list, one is the state list, one is the concurrent. The concurrent list means both state government and central government can share it. They can perform any activity. So this is one of the question came in previous thing, and language is also one of the question it came, and anti-defection law. This is 9th schedule. 9th schedule, what it is mean? Whenever any new act came, anything, if they added in a 9th schedule, no one can challenge in any court. In any court. That is the reason most of the people, they are demanding a reservation also should be added in the 9th schedule. That is the greatness of this thing. If the act has been enacted and they added in, supposed in the 9th schedule, then no one can challenge in any of the courts. Okay. Anti-defection law. Anti-defection law, what it is mean? It is in the 10th schedule and 52nd amendment. This is asked multiple times, 3 to 4 times in the last 5-6 years they asked. What is anti-defection law? Anti-defection law means the person, you know how the elections going on in India. They will get the B form from the particular party. Party heads will give the B form. Then they will go for the filing the nomination from the particular from a party A is there. He will issue the B form. So he will go and file the nomination, and after winning, he will jump to the another party. Actually, he has to bound with the party A only, but he is bound jump to another party, some XYZ party he is go. That is anti-defection law. So how this anti-defection law, it is protected the elected person to stay back in the same party. That is they enacted, but it is not perfectly going on. This is completely again state governors. It's in a state governors. They can control whether it is they can disqualified or qualified. They will decide finally. They have the full rights. So, but still anti-defection, if you see that most of the times state MLAs and all these people are jumping here and there. This is the anti-defection law. So panchayats are introduced in 73rd amendment and municipalities and 74th amendment. So just I gave the notes here, just take it down. And this is the one of the question also from which concept, which of the part is borrowed from the which country. So broadly it is complete list has given, but they ask the one of the last one of the question it is asked.
Rajkumar, can you zoom, Rajkumar?
Sorry?
Can you zoom?
Increase the font size, like zoom in.
Yeah. Now is okay? Is okay now?
Yeah.
Anyhow, I'll share this PDF with
Still more zooming is okay.
Okay.
Yeah. Okay.
So this concurrent list, just now we discussed the concurrent list. Concurrent list is in Schedule 7. So if you see the Schedule 7, this is the concurrent list. From which country it is adapted. So that is in Australia. So this is the freedom of trade, commerce, intercourse. This is the 19E, sorry, our fundamental rights. So from Australia, sitting 2 houses of the parliament, like a Lok Sabha, Rajya Sabha. This is adapted from this one. Canada is in a federation with a strong center. Federation means the state and the central. Our is a federal country, state having a full center having the full control over the states. So that concept has been adopted from the Canada. So residuary powers in the center. So total complete powers in the center only. So they want so there is rule is not some particular state is not following rules, so they can impose that presidential rule. They have some rights, so they has to voting to apply that is a different concept. Even I don't know depth of the knowledge. So appointment of the governors, our states having the governors, that is done by the center only. Center will appointment, that is Canada constituency, it is we adopted. So advisory jurisdiction concept. So like Ireland, Irish, this is a DPSP. DPSP is adapted from this. This is a chapter 4. So nomination of Rajya Sabha, how the election will be done, how they selected. Rajya Sabha member is not directly elected by the people. Only Lok Sabha people elected by the election. We vote the people to elect the Lok Sabha member. But Rajya Sabha member, it is indirectly elected. What is the process? That is Ireland, it is there. So method of election of president. President is also presidential elections in India. That is from Ireland. So Japan is a procedure established by law. This is I don't know much. Sorry about this one. So like a fundamental duties, part 4A. So social, economic, and political in a preamble is a Soviet Russia we adopted. So parliamentary system, UK we adapted because UK has been ruled so many years. So many things have been adapted from there. So rule of law, legislative, single citizenship, cabinet system, our central cabinet, state cabinet, this writs, parliamentary privileges. What are all their privileges? So bicameralism. I don't know this meaning. From United States fundamental rights, whatever we are studying, fundamental right, they adapted from the United States. So part 3, independence of judiciary, judicial review, article 13, impeachment of president, how we can remove the president has been elected in Irish, as per Irish, but how we can remove the president, till now it is not happened, fortunately. But there is a rule, it is adapted from there. So removal procedure of Supreme Court, High Court judges, how we can remove the Supreme Court. Last time one Bengal High Court judge has been done so much fraud, amount got so much amount collected from his house, but that is not easy to remove his judge position. That is a very difficult actually. So 100 members, I think so, from Lok Sabha, they has to sign it and petition, file a petition in Lok Sabha, I think so. That is a process. So very big process this. So office of the vice president, what is his election and his powers. So German is in actually when suspension presidential rule or emergency will come. Emergencies will when war is there, India is going on war, something like that. So that time fundamental rules are applicable to all citizens, but whenever the emergency is there, this is suspended. Fundamental rules are suspended immediately. So there is no fundamental rule applicable at the time of emergencies. So national emergencies, not a state emergency. State emergencies is like a presidential rule. That time it is not there. Only this is a national emergency. So South Africa amendment for constitution. So how we can amendment the constitution? So election member of Rajya Sabha. Here also it is there. Okay. So nomination. This is a nomination. This is how to nominate Rajya Sabha members. So some Rajya Sabha members nominate not elected directly. Sachin Tendulkar, some people, sports people, some extraordinary people, they are nominated. Anglo-Indian now it is removed. 2 members are nominated from 2 or 3 members, I think so, nominated to Rajya Sabha without having any election. procedure of election. So this is the thing, South Africa election of Rajya Sabha members. This is the thing, that is a nomination. This is a election of Rajya Sabha members. So Republican form of government, France. So this is the idea of liberty, equality, fraternity in the preamble. This is equality. This is laterly added some in preamble. So this is the thing. So now, okay, is this okay? Fine. Let's go to next topic.
Yeah, yes, sir.
Yeah, okay. Just we'll see some case laws. After that one, doctrines. After that one, we will solve some questions only related to Constitution of India. Okay, first, this is a preamble based question. What? So this is the Beruberi. Beruberi is one of the place.
A little bit is zooming required, Raj.
Sorry.
Rajkumar, left panel, close it and yeah, zoom it.
Okay, is now fine.
Yeah, I think it is fine now.
Okay, fine. Thank you. So this is a Beruberi case. The Beruberi case, what it is that one actually this is a border issue, India-Pakistan border issue. So when they are dividing, the part of the Beruberi should come which either India or Pakistan. That is the main case. So that dispute has been between the in India. Then Parliament has been amended so whether Constitution India can 1950 Constitution India has been enacted, but preamble held not part of the Constitution amendment purpose. Article 368 not applicable to the preamble. The judgment is this is actually, you remember that one. This is a border issue. I don't know depth of this case law because this is a very not usual case. This is not used also. So this is a preamble based. So you know Keshavanand Bharati. Keshavanand Bharati, this is a major basic structure in doctrine of basic structure. So whether we can change the preamble. So it is said that one we can change, but basic structure should not be amended. That is the judgment has been issued in the 1978, and they produced, I think 2.5 years they took. So that is a this is a Keshavananda Bharati. Basically, this is a land reform. The Kerala government land act there has been enabled. So they want to acquire. They put a ceiling of the land. So each person should be having this much land or some. So these guys having Keshavananda Bharati is a mutt, is maintaining some regional activities, religious activities. So he having so much land. So they while they acquiring that land, so he went to the court. So why this land act came into the picture initially? That is a very interesting actually. I investigated a little bit actually on that one. So we'll go to the Bail Act just now. Just we'll discuss quickly in a 2 to 3 minutes. So if you go to fundamental rights. No. One second. Part 2. See, this is a fundamental freedom. Here, if you see that protection of Article 19, if you see protection of certain rights and regarding freedom of speech. So it is in there are 6 freedom of speech and expression, assembly peacefully without arms, and cooperative societies is form unions, something like that. So if you see this F, this is a right to have a property actually. This is earlier right to have a property. How we can check it? If you see this is called amendment. Whenever you see the number over here, you can see footnote. There is a 3 over here. Particular, why it is mentioned over here too, this you can go to the particular same page. If you see in your book might not be the 1 or 2, it might be the numbers might be changed in your books. Okay, don't confuse, but compulsory one number is there. If you open your barracks and you check it right away without having any confusion. Okay, here it is in a 2. If you see 2, oh sorry, footnote, you see subclass is omitted. This is omitted. What is omitted over there? That is in a every person right to have a property actually. So everyone challenged, even Shankari Prasad, Golaknath Punjab, those guys are land reforms. When Punjab having a land reforms act, they put a land ceiling. Jamindari system earlier it was the Jamindari people, they have more lands. They used to collect the taxes like that. They have the one of the one side rural. So they abolished the Jamindari systems and the Land Reforms Act and the ceiling, putting a ceiling act. So initially they challenged based on this one. So there is a right to have, as per article, we have the proper right to having a property. So they mention over it. So this has been completely removed. So this is a, you have to read like this one. IBID means same as above. Same as above means the Constitution 44th Amendment 1978. This is a 78. It is amended and it is omitted completely. This is removed, and this is removed. This is a fundamental right. You can have the property, but it is not a fundamental right. This is not basic right of a person in India. Okay, fundamental rights are applicable to all citizens of India first, but they removed this portion and they added into 300A. If you go to 300A again, same amendment, 44th Amendment 1978. Can you open 300A please, everyone?
Right to property.
Exactly, 300A, it is there. A is an amendment, okay? See 300 per person. This is amendment. So if you see this number 3 is the chapter 4, right to property. This right to property removed from the 19(1)(f) and they added over here. So this is the right to property is there, but it is not a fundamental right. It is not a fundamental. No person shall be deprived of his property save by the authority of law. So if you see that number 3 here, if you read. Inserted same 44th Amendment 1978 with effect from, this is the 26th June. So this is the thing what happened background. So this is 76 happened. So after that one, 78 they amended based on this rule. Actually, based on this judgment, they amended that rule. So they removed that one and they added into separate sections, separate articles. Sorry. So coming to the Article 14. Article 14, you do one thing. Just it is in a time-consuming process to explain all these things. Just to go through that case laws. Just I'll tell you that important, very important one. I'll tell you this under 14 article what it is. Just I gave you what is the fact of case and what is the judgment it is pronounced. So just you go through this one. This is a Menaka Gandhi very important. This is in a golden triangle case. Whenever the question mentioned what is the golden triangle case, Menaka Gandhi. What is the Menaka Gandhi case? So they took her passport. When she is traveling to abroad, the government took unauthorizedly, they took her passport and impounding the passport. So she is asked, she has having the right. So what is your right to take your right to take my passport? So she challenged under Article 14, 19, 21. Why golden triangle means these 3 articles, 14, 19 and read together. These 3. So freedom 19 will tell that freedom of one of the cases there. Now we have to freedom of roam anywhere in India, and 14 something and 21 also same thing. Like you go through that one, please. So Indira Shevani, this is one of the famous case. This is a so reservation case. Indira Shevani, mostly Mandal Commission case it is called. So what she challenged on the reservation. So on the reservation she challenged. After that one, Mandal Commission has been established. They suggested to not cross the overall percentage. 50% should not be crossed. So still the fighting is going on to increase this cap. So they gave the OBC reservation 25 to 27%, under SC ST some, totally you should not cross the 50%. And they introduced the creamy layer. Creamy layer, mostly creamy layer what it is mean that, so suppose any MLA MP, so they are in the positions, their successors like a son or daughter, it is reservation is not applicable to them. And second thing, the person who is employed, SC ST BC OBC, who has been employed and is earning some cap, now 8 lakhs or 10 lakhs, I don't remember exactly, is earning per year 10 lakhs. Actually the reservation should not be applicable to him. That is a creamy layer. Creamy layer in how on the top of milk the cream we will remove, na? That way it is removing the taking out some people from the reservation category. How, what is the based, some rules and regulations, that is a creamy layer has been introduced here only. But no, because of our Indian system or political system, they are not following properly. That is a different story. So the Visakha case is actually fundamental right 19, the woman sexual harassment case. This is also one of the important case. So under Article 14, right to life and right to dignified life. Actually, right to life. If you see Article Bare Act, right to life, right to dignified life, it is mentioned over here. So whenever the women women are working in working places, they should have some dignified life. So sexually harassment. So, this is the case related to that one. So if you want interested, you can go in depth. But my gut feel is should, as per exam purpose only, go through this one. Okay. This is one of the major Shehara Bano case. This triple talaq case 2017. Triple talaq has been banned. Shehara Bano. This is one of the repeated questions. This is of course family law. It will come, but this is also talaq biddat. This is permanent divorce, actually unconstitutional. This is they declared unconstitutional. This one I'll tell you the background, little bit background in 2 minutes, because if you read straightforward, you might not remember some background, like connecting dots if you give. So if you can remember properly. One second. So related to Shehara Bano, just how it came up, we will see just Shehara Bano. So I'm sorry. So there are 4 type of talaqs. Talaqs means divorce in a Muslim law. So there are 4 types: talaqi sunnat, talaqi biddat, contingent talaq. This is a delegated talaq. 4th one is delegated talaq. This is also one time question came. Talaqi sunnat means this is a recoverable talaq. Recoverable divorce means something, some small things they quarreled, or they want to revoke, they want to cancel their divorce. So that is called talaqi sunnat. This is a good thing only, because people come together again, wife and husband. But this is talaqi biddat. This is a talaqi biddat means 3 times they will tell talaq. That is a divorce. That is a complete divorce. They cannot together again. That is the Shehara Bano 2017. She challenged in a Supreme Court. Okay, regarding this triple talaq. After that one, what they did, they enact Muslim Women Protection and Rights and Marriage 2019. They created after 2017 after judgment. Then the triple talaq is completely banned. And if it is pronounced triple talaq, it is the punishable offenses. they will put some jail, something. They have some. So this act came into the force in the 2019 based on the Sahara Banu 2019 triple talaq case. The third one is a contingent, conditional divorce. So conditional divorce means if you do some activity, I won't give divorce, or if you some based on some conditions. I don't have any proper uh, explanation for this one, but conditionally they will divorce for some time or some period of time, or uh, something like that. I cannot went into in depth that one, but here in the Muslim, actually they can go for the four wives. Their customary law, that is a custom and usage. Customary law, this is a customary, not uniform code. India does not have a uniform civil code, so still struggling to enable uniform civil code as part of our DPSP. But because of some religious restrictions, they have some their own customary laws. So in the customary law, Muslim person having a four wives, if he wants to go with the fifth wife, mandatorily has to divorce one of the lady, and he can go for the marriage of the other lady. So totally overall, you should having the four wives only. That is a customary law they have. So condition of divorce like that. So if I marry the other one, this can be divorced. Something that I'm expecting. I'm not sure about that one. This is a talaki tafiz. This is a delegated. Delegated means a person will delegate to another person, like mother, father, or brother, or sister. Instead of pronouncing talak by the husband, he can delegate to others. His mother also tell to either daughter-in-law, it is a divorced to my son, or father also, you divorced my son, you can go away, something like that. So it is delegated. So these four types. This question came into once. This biddat also came. This biddat related Shahara Bano triple talaq case 2017. So this is one of the case, and we will continue little bit one of the case. This is also repetitive case in family law. Shah Bano. Don't confuse. Shahara Bano is a triple talaq. Okay, Shah Bano is a maintenance case. He divorced, but he is not given any maintenance to her. Actually, in Hindus, they will give every month. They has the person, husband has to give the maintenance until unless she have the any second marriage. If she has illegal any bigamy is there, he can stop giving the conditions. He can stop giving the maintenance, or any illegal relationships, or she married second time other person, then you can stop giving straightforward. So in Muslim, what they did at the time of doing marriage, they give the meher. Meher means the husband will give some amount to the wife. That is not fixed, that amount or gifts or whatever it may be, how much their financial positions, they will give the amount. So that is the meher. So iddat means the divorce. This is the iddat means this is a divorce actually. Iddat divorce for 3 months. If they given divorce, the 3 months has to pay the maintenance. Only 3 months to wife. That is the thing. Actually, in this case, she won the case. Actually, maintenance case, every person, woman has to pay. Every husband has to pay maintenance to her. So Muslim people has been fighting against that because their argument is, already we are paying meher at the time of marriage, we are giving some amount, and in that period also we are giving some amount, 3 months. So again, why need to give the amount? That is their argument. So then they enacted one of the act, like Muslim Women Protection Right Divorce. This is a Marriage Act 2019. Keep remember. And this is a Divorce Act 1986. This is a 1985. This is a case in 85 year. This is a 1986. So they mentioned they mentioned over there some section 5, I think so, section 5 in this Divorce Act, Muslim Divorce Act. So they mentioned that one, wife and husband together has to understand, and both consent is there, then only the husband can pay pay maintenance to wife. Something condition is there. But that has been Daniel Latif and versus Union of India. Daniel Latif challenged this act, 1986 act. So he's saying the same thing. Uh, he's saying same thing. The meher has been already paying, and at the time of iddat, divorce, we are paying again and again. Why we need to pay? Then in this judgment, what they give, both the parties should agree for this, agree for the divorce and maintenance. Then only give. But usually the person who why he can give the maintenance, because he's having other three wives. He has to maintain the three wives and kids. So usually this is not possible case. Though the woman has to go have in their relatives are Oxford. Oxford means Muslim boards. Muslim boards, they has to pay something. They gave the judgment. This is the background. Shabano case maintenance background, and this is the Shaharabano. Just remember, if you are interested, go through so many videos or something like that. You can gather information. So I'll give you this information, so you can keep it. So this is the background of this one, Shaharabano. So coming to Indian English, if you leave this one, if you are interested, then you can go to same Navtej Singh Johar. This is a sexual relationships case only. That is under Article 14 and Article 15 and 16. This is a State of Madras, Champak Dore Rajan, M.R. Balaji, N.M. Thomas, K.V. Vasant, Indra Shavani. This is again Indra Shavani, same reservation case. Renuka E. Chennaya. So article wise, just I gathered information. Article, this is Article 19. Article 19, you know, very familiar. Sakal papers. This is a prize. When prize and number of pages case, we read in this one. And Bennett. People, you remember actually MC Mehta. MC Mehta case is an environmental case. Environmental MC Mehta, whenever it is come, this is an environmental case. Always remember that one. This is a part Tata Press. Article 21. Article 21 again Menaka Gandhi, it is came up. Olga Tellis means in Bombay what happened, the people roadside on footpath, they are selling items. Footpath sellers are there on footpath, they occupy the footpath, and what Mumbai municipality, without having any mercy, they removed that all the shops. So in Olga Tellis case, this person went to the court and against this municipal corporation. So this is a livelihood. Their part is a livelihood. We have to provide some provisions for them. So this is the dwellers pavement cases. This is called dwellers pavement cases. They asked dwellers, then Olga Tellis Mumbai Bombay Corporation. This is also 2 times they asked. So come to doctrines. So doctrine also I gathered the same information. So if you see that doctrine of basic structure, you know this one, main Keshavananda Bharati, it is came up with the Keshavananda Bharati. So whenever it is asked Keshavananda Bharati, you can mention. So basic structure can be amend or not. That is the basic structure means basic things like a fundamental rights. This is a severability. Severability means suppose like an example I'll tell you. Example, any new act into enforced in Indian Parliament has been approved, and presidential assent has been done. So there are example I am telling, there are 15 sections are there. So among 15 sections, there are one or two sections are not following fundamental rights and fundamental. They are violating fundamental rights or duties or something like that. So you can challenge. You can challenge on those things. Even as it is, in order to follow, you can challenge on the acts. Even criminal laws, one person has been challenged. Still, it is going on. I think so. So you can challenge on those one. So if the Supreme Court feel that one, those two are illegal and they are not supposed to be added in that one, they can omit. So that is a severability, separability. They will separate those two. Entire act cannot be taken out. Entire they cannot remove entire act. They can separate those two, and remaining can be followed. Though those two will be repealed, something like that. They will amend or repeal, something like that. That is a severability, separating. This is an eclipse. Eclipse means this is a before pre-constitutional law or post-constitutional law. How you can remember? See, this Constitution of India enacted in 1950, right? So contract law, many of the laws 1872. So before law, we are even 1960 IPC 1860. Still after independence also we are following, right? IPC 1860 we are following after independence also 1950. So this doctrine of eclipse after constitution enactment, we can follow the old acts also or not. Eclipse means covering. So yes, we can follow. So we cannot until unless the fundamental rights are not violating, we can follow those things. That is a thing actually. Eclipse, doctrine of eclipse. So doctrine of waiver. So unfair assessment. So this is a tax related, I think. Though tax tax is waived. So fundamental right, width and substance. Anyone can add actually. Anyone can add. And actually these doctrines I don't have much time to check in depth. So till case laws, I do have a work background work before giving lecture, but unfortunately I don't get time to search all these things in depth. Just I took a note and I kept it over here. This is a union Pitan Samsan union list and state list, 7th schedule. This colorable legislation. Better you can go through this one. Just we'll jump into the question and answers, because only one question it can be expected over here. So simply you can have a glance over here. So this is harmonious constructions. Whenever the conflict between any two things. So any conflict in question, any conflict is there related to harmonious. This is the harmonious construction. Conflict comes in question. Then apply the harmonious construction. So here usually one of the question came 25 subclass 2 subclass B and 26B. There is a conflict between these two articles. This is the occupied field. So there are around 20 I gave, I think. Just you can go through all these things. Try not to remember, just at least have a glance so that you can remember. This is also Latin terms, legal maxims. Adi alternate pattern. Adi alternate pattern means here other side also you have to listen. That comes under constitutional law and administrative law. So case law is in a passport impounding case. Nemo judex casa su. No, this is a judex means judex. No one. So suppose example might be sometimes judge himself cannot do on his own case. I mean arguments in own case. No one should be judged on his own case. This is related to that one. Actually, AK Kraipak. This is I don't get into the depth in this one, but you remember this one. Nemo judex. Judex means judex judge. Judex means judge. Judge cannot himself judge himself in the cases. This is also two times came. It's a bona fide, good faith. Usually we'll get in from the colleges whenever quitting. Bona fide and mala fide is a bad faith. These are the habeas corpus. Again, writs came. Mandamus, censurary, prohibition, covarento. Locus standi. Locus standi means stand before the court, right to be heard or to sue. Stand before the court, actually. Same. This is applicable in Article 32 to 26 in writs. Post facto laws. Law made after the act. Res judicata. Res judicata. This is an civil procedure code. Section 6, I think so. This is already decided. This is res judicata means this matter has been completed. This is already decided, closed. Sub judice. This is also civil procedure. Section 10. Section 10. A matter under judicial consideration. Meaning has been given. Just you remember. Mens rea. This is a guilty mind and guilty act. There is no guilty act until unless you have a guilty mind. You have an intention to do some wrong thing, then mens rea is applicable. Actus rerum, guilt act, this one. Until unless guilt mind is not there, actus rea is not there, guilt act is not there. That is also, it also came multiple times in the exam. Dicta, things said by the way. Ratio disdendy. Ratio disdendy means a reason for the decision. Just what is the reason for the giving binding part of the judgment. So Article 141 it is now. Olati non-fit injuria. To a willing person, no injury is done. This is also very much important. Ubi just ibi remedium.
Remedy.
Very, very important. Where there is a right, there is a remedy. We have a right and we have the. This is also case laws. This is an actually damnum sine injuria, damage without legal injury. This is comes in a tarts actually. Gloucester Grammar School. Gloucester Grammar School. Do you remember? Just I'll give you. I read yesterday only. So one person having a school in one area. So so it is running very well and good strength is there and is having good financial gaining is there from that school. But suddenly one person split into that school and started nearby one more school, same kind of way, and some people are splitted into that school and went into that school. Few students are took TC from this school and joined into that school, second school. So this guy will go to the court. So this is the way he is a competitor. So he is put a opposite to my school is kept a school. Then this came into the picture. Danum sine injuria. It is a damage is there for him. Financial damage is there, but there is no legal injury. There is no any injury for him. So no compensation. He is asked for the compensation basically. So he lost the financial losses. He has to bear that losses. So the judgment gave that one. You have that damage, but there is no legal injury. So that is the thing actually. This is opposite to this one. Injuria sine demon. So there is an injury, but without any damage. You might have read this Ashby versus White. I think this is a dam case, na Ani Prasad? Dam has been constructed, something like that. I read very long back during our exams, but I forgot this one. This is important. Just remember you those two case laws. This only two case laws will come actually. Gloucester school case, school case. Just remember that one. Damnum sine injuria, and opposite Injuria sine dinam. Damnum means damage. Sine means without. Injuria means injury. This is injuria. Injury without damage. Just reverse. Just reverse. So this is the Ashby and White. Q facet for aluminium. Quasi judicial. Res ispa locator. This is also one of the repetitive question. The things speak itself. In thoughts it will come actually usually. Oh, again it is repeating. Ubi just ibi idem remedy. Where there is a right, there is the same remedy. Kevi tempter, the buyer beware. Actually, these whenever it will come in a consumer protection. Consumer protection, whenever you are buying a product, you should be aware of regarding that product. You should know some knowledge. You have to gain. You go and ask the product knowledge. Without having any knowledge, you cannot buy. That is saying this legal maxim. Caveat emptor. Emptor means buyer. Buyer. We need to know. This is the caveat vendor. Vendor means who is selling. Seller. Seller means vendor. So seller, be aware. So if something, if TV is there, some futures might know TV versions, version 1, version 2, like a car. If you see Maruti X, XS, L, something like that, some versions are there. So in this model, these are the features. In this model, these are the features. Seller has to give complete information. So you should aware and give the complete information. That is called caveat. Venditar. Inter alia, among other things, just cognizance, compelling laws, international treaties cities come. So that's all. Around 30 I gave. So if you see these are the repeated, around 10 are repeated over here. Just go through this one. You have to be remember until unless see, it cannot be given in any of the acts. So this is outside of our bare acts. So should mandatorily remember and do some technically you remember and read something you do on your own. So I gave some notes this one also. So under article part 3, under article 12 to 35, this is a definition of state, very much important. What is the state means? State means not a state government. What is the state? State means one organization, one authority. A parliament is a state, legislature, local assembly is also state. Some like electricity board is a state government offices also one state. Like what is not state? BCCI. BCCI, our cricket control board, is not a state actually. They have whichever the state has been declared, they has to protect citizens' rights, citizen fundamental rights. They has to protect, like a state government, parliament, any educational institutes, like government institutes which are funded by the government. So they are the people are salaried by the government, they are getting. So the people has to protect. Whenever we go for the particular information, they has to give. They should not deny our fundamental right things. So this is the first case actually related to Article 2, University of Madras and Santabai case. This is one time it came. Ejusudum generis principles actually. Only authorities with government functions are states. University is not a state. Initially they said that for university, but this is overruled later. This is the Electricity Board Rajasthan and Mohanlal. This is also Electricity Board is a statutory body. Actually, it is considered as a state or not. Then it is in a state only. Function. Actually, this is initially it is not necessary. They said, but later they added, because who are getting the government salaries, because they are bound to government. They are responsible for the serve to citizen people. So Sukhdev Bhagwat, this is a very important case law. This is what are all the statutory body. Two times it came actually. So What are the statutory states, LIC, ONGC, IFC, BPCL, IOCL, all these government and semi-government offices. This is CSIR, Scientific Research Council of Research, Scientific Industrial Research. This is also comes under. This is also R.D. Shetty, Ramana Dayaram Shetty Airport of AAI agency. This actually this is a government funds who are getting government funds and government salaries. These are considered as in a state. This is the meaning of state actually. So this is a vast subject. This is a state actually. Still, it is some conflicts going on. So these are not states actually. Private unaided schools, unaided minority schools, BCCI. So whenever the question is comes, which is not come under state, if they ask BCCI, simply blindly go with the BCCI. So this is the notes. Just you go through this one. Just I gathered somewhere while studying. I gathered information. This is the pre-constitutional, post-constitutional. This is comes under harmonious. Not harmonious. Doctrine of eclipse. Harmonious construction means whenever the conflict is there. Construction means conflict. Whenever the conflict is there, that this is the notes. Just you can go through this one. Simple notes only. You can go through with your own. This is already 1.5 hours. Is it interesting or it's boring? Hello. No one are there in the call. Huh?
சார் இன்ட்ரெஸ்டா தான் இருக்கு, கண்டினியூ பண்ணுங்க.
Okay. Sorry, just I am asking because I am only the talking. So even for the Kamakshi also same thing. And also this is also this very important parts I included over here. Like in emergencies also, emergency, national emergency, state emergency or constitutional emergency, president rule. So financial emergency. These are the emergency, national emergency, Article 352. These are the very much important. Just to go through this one. So how much validity is there? If the approved by the parliament, 6 months is the validity. So after that one, parliament again reapprove this one. It is not approved only 1 month. It is normal. It will come into the normal. So maximum duration, there is no limit. So the parliament every 6 months they can go revision of emergency, national emergency. This one. So challenging the proclamation. This is a Minerva Mills. This is one of the case. Emergency proclamation case means Minerva Mills case. So state emergency like the 352 and 356. This is enough. Center imposes emergency, state emergency and state. So this is also parliament has to be approved 6 months. You remember this why I mentioned over here. They will ask national emergency what is the duration. State emergency what is the duration. Who is the authority? For state emergency, who is the authority? Parliament is the authority. State emergency, assembly, local assembly is not authority. State emergency means completely the government has been dissolved. The CM, ministers, all state ministers, all are got dissolved. So that is the period of 6 months they can impose. So do you remember? Might be in our period, Bihar has been done 10 years back, I think so. So recently this one also Assam Boda cases also they put a state emergency. So the parliament has not approved 2 months only it is valid. Maximum duration 3 years. So after 3 years you have to do some activity, some re-elections or something has to be done. So this is the financial, just financially whenever the financial emergency, this is parliament only. This is also parliament indefinite. So it is approved by parliament 2 months. So due to the financial things, the government bodies cannot run the governments. Then financial government can impose. So you take it all these. Just I forgot to highlight all these things. Just remember, and all these 1 or 2 times it came. This thing. So don't afraid. If you see, you need not to remember. If you open state emergency 356, it is very much is there. So I'll open, I'll show it to you. Just if you what if the emergency is there, you need to remember, okay, Constitution India Bare Act has to open. So if you see emergency in this thing 350 from 350 to 356, so you have to be search carefully. So I'll show you right away. It is not personally done. Actually, everything is mentioned in the Constitution. We have to strictly have to follow. That's it. So, oh, 350. Do one thing, just a small underlines with pencil. So if you keep plain, it is very difficult to identify. Just open, and wherever the 6 months are there, 3 years, see this one, 3 years. I'll show you 352 national emergency, so that you have a better idea. So proclamation of emergency provisions. It is in a you remember part number. This is the Roman numbers. You have to read the Roman numbers on the 10, 5, 3. So 15, 18. This is the 18. So be familiar with this part numbers also. So if you go to the 20 above 30, so you have to remember. So if you see this one, you underline in your book with the pencil very. You can only identify that one. So if the invigilator, some people saying that one, some centers people won't accept, some centers will accept. Different comments I got it. Actually, it is purely based on the examiner. Will Bare Acts will be allowed. Some examiners will allow, even though if you have an highlighters and something, if you write extra paper sticky notes also they will allow. So this is, you see this proclamation, the so approved shall be unless only revoked cease the operator expiration of the period 6 months from the date of passing of the second resolution approving the proclamation under class 4. You have to big paragraphs you have to read. So you read once and you underline wherever the important sections. Again here also cooperative 6 months. So this is I mentioned over here simply. So Article 360, Parliament has to be 6 months, and if not approved, it is in 2 months. Maximum duration 3 years. 356. You see, you can see these figures in the Bare Acts. Definitely, you can see. So you underline with the pencils. So we'll go to the case laws now. I'm sorry. We'll go to the questions, MCQs. Before go to the MCQs, just we'll see. This is one of the trickiest questions. That's what when I am reading this, I got noticed. So in which of the following case the court has laid down the right to life does not include right to die. So actually, what happened? Right to life is in Article 21. If you see a right to life is in Article 21. So what? Why she went to the court? So she wants to die for particular reasons. I'll tell you the background of this one. So what happened before 1994? P. Rathinam versus of Union of India challenged IPC 310. IPC 310 attempt to suicide. Why attempt to suicide is a criminal offense? So she challenged, and we can challenge actually. This is what I am saying. This is a through writs you can challenge. So she challenged, constitutional challenge. So right to life includes the right to die. She challenged. So Supreme Court declared that one. This is unconstitutional. This offense is unconstitutional. So this is again 1994. Gyan Kaur and state of Punjab This is overruled this judgment. They included right to life is not included right to die. Actually, this in this case, P. Ratnam case, right to life is included right to die. They declared that one. This is unconstitutional. This is unconstitutional. They said that one. This is included, but overall this one in a Gyan Kaur and state of Punjab case. So again in 2011, what happened? Aruna Shanbag in this is actually Kerala, one of the nurse case. She raped by some other gang, one of the gang, but she is so much hurt. Actually, almost 37 years she was on bedridden only, without unconsciously. So they want she's a journalist. Pinky Virani is a journalist. She filed a petition on the passive euthanasia. Means she's on a ventilator. Actually, she's on ventilator. They put on a pipe for the breathe, artificial breathe. So she cannot do anything. So she is sustaining based on the medical things, on medical treatment or something. So she want to die. So this journalist, the lady went to the filed a petition. She want passive euthanasia. So she want to whenever remove this ventilator, she will immediately die. But in our Indian constitution, it is right to die is not a part of constitution. This is a right to life. So they are not allowed medically. They are not allowed. But she went to the case, but they allowed based on the passive euthanasia. So the ventilator has been removed. She died after that one. But after that one also, they put a file common cause. So simply, if she want to die, someone go with the knife and she can cut the throat. It is not like that. She can die in number of ways, but it is not right way. It is in a one proper way. One proper way means how it is. Actually, it is in a the court upheld the legality. Passive euthanasia established guidelines for the living wills, advanced medical. So what they say, what they legalized that one. It should be a dignity way. The right to die also, it should be a dignity. She can go for die, but by removing simple ventilator, she can go die. But instead of removing ventilator, we can cut the throat. It is not the right way. That is the thing. One of the example I am telling. So this is the common cause. This is one of the organization. They challenged the 2018 right to die with a dignity way. This is the thing they pronounce the judgment. So after that one, this is one of the case. So remember, you read the question properly always. This is the tricky they will give. Right to life includes right right to life includes right to die. Then this is a P. Ratnam is the answer. Not means this is the answer. Srimad Gyan Kaur and state of Punjab. Okay, this is a passive euthanasia. They mentioned in the question. Then Aruna Shanbag, Union of India. So this is the right to die with the dignity in the question. Then common cause. So this is the link. This is the connecting dots. So you remember this small story. So it will be easy. So based on this, the Supreme Court held the legalized living wills and passive euthanasia subject to certain conditions in the set of case. This is the question, one of the case, common cause, Union of India. This is what one of the question it came up. So multiple times, 3 times or 4 times it came up. So this is the Article 21. It came up. Right to life does not include right to die finally. Actually, so if it includes also with dignity. So some medication by stopping the medication, but by not giving the poison, that is a mercy killing. Mercy killing is different. Don't confuse. Mercy killing, how it is. So they will give some poison or current shock, something like that. They will give some external things they will apply to die, for hanging, something like that. But it is not like that. This is a simple way. They could not able to do. The person could not able to survive. They could not able to do any activity. Just simply bedridden. some support is there, ventilation support, some medical support. Without having medical support, the person cannot survive in that cases. Okay, this is the thing. And this is one of the case, if you remember, this is the harmonious construction. This is harmonious construction, Minerva Mills. This what happened is a fundamental rights. There is a balance between fundamental rights and directive. This question is little tricky. This is also basically the people will get confused as basic structure doctrine, basic structure constitution. They will see immediately, they will choose Keshavananda Bharati. They will choose Keshavananda Bharati. You are gone. 1 mark is out. So you read the question. Why I am mentioning over here, especially the fundamental rights and directive principles. There is a balance between these two. This is called doctrine of harmonious construction, conflict between two. This is the under the case of Minerva Mills. If you want what is the Minerva Mills, go in depth in your this is where I mentioned harmonious construction. Okay, so this is the thing. This is also one of the same thing, like among following is not included right to life, right to life, right to die, right to suicide is not included under article. This is one of the question. Okay, not right to privacy, right to good health, right to die, right to life means not to right to life, not okay, not included. Just you have to be careful. Sometimes what they will ask, which of the among following is included? Is included means that is a different answers that you have to be carefully read. When not is there or included is there, you have to be careful. Confusion question, 1 or 2 questions like this one. So you have to be careful. So again, I mentioned what is the this is the constitution. After constitution, these are the mostly property related. First, Shankari Prasad, property related. First Amendment Act 1951 curtailed. First Amendment 1950, our constitution has been enacted. After 1951, the right to property he challenged. So what is the judgment? What is the fact of the case, and what is the judgment of this? Very briefly I gave. So after that one, Shankari Prasad, what they told, this is the power amend to any part of the fundamental rights. First, initially, Sajjan Singh case, this is also ninth schedule. Ninth schedule, what it is, I told you, whenever that act, anything added in the ninth schedule, they cannot, that is we cannot challenge any courts. Ninth schedule, that much dangerous actually. Okay, so he is saying that when Parliament has the power to amend any part of the fundamental rights, it is in the case it is delivered the judge. But Golaknath case again overruled. So overruled the Shankari Prasad. The above case it is overruled, and it is saying that when this is also Punjab Reforms Act. So you have a doubt anytime. Actually, in one case they will give can amend, another case they cannot amend. Why this conflict? Because we are following only one constitution. This is all interpretation. How you interpret, how you argue, interpretation of clauses. We read one of the thing. This is as a lawyer, as an advocate, how you interpret the subject matter into the facts of the case into the courts. So based on the advocate, it will decide the matter. So how intelligently, how strongly you debate or you argue in the court, so that will value addition to your client. So be careful about these things. And drafting also very much important. As an advocate, first you learn drafting skills. Drafting is very highly. So by seeing the draft itself, 80 to 90% of the case can be decided. But it will be, judgment will be delayed. That isn't different. But drafting is that much key role. Senior lawyers, especially very seniors, they won't give much time to meet other people. Even if you go juniors like that, they won't give, because they are mostly they spend on drafting only. So after that one, Keshwananda Bharati, this is here it is included a basic structure of doctrine. Before it is not there. Basic structure of doctrine it is included, but they said that one Parliament can amend any part, but fundamental constitution including fundamental rights, but basic structure should not be disturbed. Cannot destroy the basic structure. Okay, I'm sorry to say, actually, what is the basic structure? I don't understand still now. Because if they want to amend the fund, I need to, because see, the people still they are doing, I came to know that one, still they are doing the PhD in constitutional law. PhD, they are doing PhDs. What is the mindset when they are writing the constitution? So what is meant for that one? How they can interpret? How many ways they are right? I was surprised actually. So what they can do PhD on this one. So yeah, I need to check what is the basic structure. Basic structure means they can amend any part. They said that one Parliament can amend any part and including fundamental. What is the basic structure? That is actually simply we are going through this one, but I don't know. Still, I need to get into the subject deeply in this one. So after the basic structure, after Keshavananda, this is called one of the leading case. So after that one, Indira Nehru Gandhi, you know, this is a person. She's elected. Raj Narayan has been defeated. So he went to the Allahabad court, and Allahabad court instructed that the election was invalidated because of the rigging, something else. So after that one, she was the prime minister. So she 39th amendment she took that one, and a judicial review. It is not subject to judicial review. She said some supporting amendment she did. Even I need to go in depth in this one. So if you touch one case, Lana, it takes 4 to 5 days, sometimes 10 days, 15 days. If you touch one case law, it is a linking one another. If you research on that one, it takes a lot of time, consuming a lot of time. So right now it is in a broadly, but it is in a knowledgeable if you go through in depth actually. So the judgment is struck down. 39th, they stopped. They held on that one. So judicial review plus rule of law is a part of basic structure. The judgment have been given. So Minerva Mills, it's a power to. I said this is a conflict between Directive Principle of State Policy and fundamental rights. This is Minerva Mills. This is also in depth. You have to see why the conflict has been came up. This is a fundamental rights, and this is a fundamental duties. So Vaman Rao is in a ninth schedule. You know, ninth schedule. There is immunity. There is no immunity. We cannot go for the judicial review on the. If anything is added in ninth schedule, we cannot go for the judicial review in any of the court. This is the thing. He challenged on this one. Okay. These are the very much important and very, very interesting. This is the latest one, electoral bond cases. 2024. Actually, the donations can be done to the parties with the electoral bonds. So they removed the electoral bond case in 2024. When we are studying second year, I think so. Second year of the LLB, this was happened actually. I do remember, but in depth I didn't go. Electoral bond cases, it's in a party fund we can give through electoral bond cases. So to avoid tax, something like that. It is also some person went to challenging this one, and so finally it is not exist right now, I think so. So this is a thing what I covered till now. So what do you feel if you take a break, or you'll continue MCQs? So hope,
Yeah, I think you can continue, Rajkumar, but you can directly go to the questions also.
Yeah,
It's
questions
very
at least we will
short.
discuss straightforward questions. We will discuss only related to this one. Actually, I already shared in the group as well this same document.
Okay.
Might be.
Yeah, so, yeah, please you continue, Lali. We'll complete in one shot.
So hope my lecture is okay, or what do you feel?
Yeah, it's okay only, Rajkumar.
Oh, not excellent. Okay, thank you.
Others okay, no?
Okay. This I feel I am expecting okay only, not about to the okay.
Yeah, it's okay. Good.
Okay, fine.
Ah.
So okay, this is the concept of freedom. Just we are this adapting which part of the constitution it is adapted, which part of the area. This is same way, freedom of trade, and we discussed in a constitution of India notes. So this is the thing. So just you go through this one. So freedom of trade and commerce, it is in Australia. Borrowed futures. So if you see, this is straightforward questions. Freedom of trade and commerce, it is in Australia. Okay, just I'll simply finish up like this one. Okay, REITs already we discussed it. This is perform public duty. You perform the duty. So what is the manumus? Mandatorily how to do the duty. So censurary, squash the petition. Covarento, what is your authority? What is your role? So prohibition, completely prohibit that. Suppose one judgment is not under jurisdiction. What is your jurisdiction? It is completely prohibit. Cancelling the order or cancelling the judgment. Prohibit. Okay, this is comes in public duties. Public duties. What is your performance? What is your as a manumus? Okay. So this is the direct Bare Act question. So how you search? Which of the following constitutional amendment act when the provisions for the publishing Hindi translation of the constitution? Everyone please open the constitution. I'll tell you how to search. Okay, this is not a direct amendment question. You cannot search direct that much easily. You see the languages included all from the ending of the articles. Total 395 articles are there, na? Do you see? You open a Bare Act book, please. I don't open any soft copy. Just open the Bare Act. You go to the part 22. Short title, commencement, authority to text in Hindi and repeals. Right? There is a Hindi word, languages, Hindi languages. You have to search like this one. Yes or no? You are searching or not?
Yeah, we are doing.
Just respond, na, please. You can involve in this one. It is easy to understand and easy to interactive way. Okay, now, and if you see, there is a word authority to text in Hindi language. So if you see that article 394A is actually whenever that letter is added, if you see in that same page 371A, 371B, only 371 is an original constitution. A, B, C added means that is an amendment. So 394A, if you see that page number, in my book it is in a 173 page number. If you open 393, go inside. Okay, 173, go inside. How quickly you search, then that is you save your time actually. So if you see the 394A, there is a one number is there. In my book, one number is there. If you see the footnote inserted by the Constitution, 58th Amendment Act 1987. Okay, it is there very much, 58th Amendment. Okay, right? Everyone got it?
Yes.
Okay, like that. If you have to, this is not a direct question actually. Indirectly, if you see some words, that's what I'm telling you. Keep going. Some initial content. Some if we go to that main content page. So if you see this content page, at least go one check 1 or 2 times. This titles, car contents, whatever the page numbers, everything is the part you can remember at least what are all the words inside our constitution or something like that. Okay, and coming to the next question, Which of the following is the landmark judgment on the colorable legislation? Colorable legislation is in a straightforward answer. If you remember the state of Bihar versus Kameshwar Singh. This is related to land acquisition in Bihar. This is the background of the case. So this is a fundamental rights violating. This is the same land case only, but colorable legislation. So Karnataka case is a doctrine of repugnancy, means that is in a state or central legislation can concurrent list. This is a concurrent list, based on the concurrent list, that is in the doctrine of repugnancy. So I wrote down in my note actually. You note down anywhere, somewhere in your note. Okay, next question. If you see, which of the following constitutional amendment act was passed in light of advisory opinion received? This Beruberi case. Beruberi case, we already read it about initially. So this is a border Pakistan India border issue. So this is, you remember directly this question. Beruberi case means 9th amendment only. 9th amendment. Not 9th schedule. 9th schedule is different. 9th amendment. This is came into 9th amendment. So advisory opinion means advisory, when advisory president can go for the advisory on this situation. Okay, that is the thing actually. 9th amendment they added. So which of the following provisions of the Constitution of India are relevant for the solving questions repugnancy between central law and state law? This is the Karnataka case. This is only the Karnataka case. So you can see directly this one, direct questions this one. So how you can see? Go to the your book and check that 248 article. What is the name? It is there against that one. 248. Everyone please go through and check it. You have to practice, otherwise it's difficult. In a direct exam, you trying to do, it is a time consuming process. Right now you do something. So 248 residuary powers of legislation, it is not. Then 252 you check it, powers of parliament legislation of 2 or more states by the consent and adoption, it is not. And if 254 inconsistency between laws parliament and laws made by the legislature, this is only the central and station. Inconsistency, repugnancy means inconsistency, meaning you write in your note, inconsistency between central law and state law. This is the central law, parliament laws by the legislation. Parliament passed one law, again on top of that one legislature, state legislature, assemblies can pass one. This has happened in Karnataka's case. That is called doctrine of repugnancy. This is one of the doctrine actually. Okay, this is what transition period was provided in the Constitution of India, challenging the official languages in Union from the English to Hindi. Actually, initially it is written, or Constitution is written in English, but that they took the time period. They initially allocated the time period 15 years. This is a AIBE 18 question. So to translate from English to Hindi, 15 years they took initially. Now there is a different language, of course. 25 languages it is there. Even Nepali also it is there. In which of the following cases was it held that there could be no reservation on the single post in the cadre? This is a very interesting case. Very interesting case. Chandradhar Pashwan and state of Bihar. I was searched deeply in this one. What it is meant? Actually, in Bihar, what happened? Only there is only one post. Only one post. One post has been so as per the rule, Mandal case rule, 50% of the 50% only assigned to reservation. Okay, only one case they assigned to reservation. So in a competitive exam, the person, open category person, this Chandrakar Pashwan, the person who is the name, the person got the rank 1. He is an open category person. So the people what the state Bihar, it is already allocated to, this post is allocated to reservation category. That's what he did not give the post to him. Instead of giving to him some other reserved category person, they opted and they gave. Then he challenged in the Supreme Court against the state of Bihar. Sorry, Supreme Court or High Court, I don't know background. So he challenged against the state of Bihar. So what they pronounced the judgment, instead of saying the court directly, you cannot put a reservation for only one seat. They gave the judgment that one. It is one seat means 100% you are giving the reservation. There is a rule 50% reservation only. You are giving 100% reservation. So you are violating the rule. They gave the pronounced the judgment like this. Instead of telling that one it should go open, it should not go to the, instead of pronouncing the judgment like that one, they simply went to that one. That one seat is there, you are 100% reservation you are applying. This is unconstitutional. So as per Mandal case, it has to be 50% only. So that should be finally, ultimately, that went to the unreserved category person. This is the background of this case. Just remember, whenever the reservation case it is there, reservation is Mandal case. Indra Shevhani versus Union of India. That is primarily that one. So this is the later Chandradhar Pashwan. This is a post, reservation post. Okay. Then ninth question: sexual harassment of the working woman at the place. This is actually you can see that Article 19 having the any person can do any profession, trade or job anywhere. So 19 Article 1 of G, it is so if you search in these articles, 19 1 of B, 19 1 of D, so don't read 19 1 of B. Actually, I'm pronouncing like that, but 19 subclass 1, class 1, subclass B, like that we have to actually terminology of law. So for ease of use, I'm using 19 of 1 of B. So sexual harassment word we cannot search any one of here. If you go through that 91 of B, 91 of D, E, G, just you have to nearby. So usually women working means job related. Woman means she is sexually harassed at the working place. Means the working place anywhere, any person anywhere. You can open 19(1) G. Please open 19(1) G and you check it. You can clear up this doubt. So practice of any profession, carry occupation, trade or business or job also include. So profession means job only. So that lady working at a working place that causing sexual. So is simply that relevant answer is 19(1) of G. Okay, got it? Any questions? Okay, this is a doctrine conflict between. This is a conflict. It is question conflict between these two articles: 25 class 2 subclass B and 26 class B. So there is a conflict means construction. Conflict, harmonious construction. This is a simply you remember conflict. This is a conflict. Okay, this is a 11th question. Little tricky. The title of the Constitution of India is laid down in. Usually, any if you see titles will be included in a section 1. Section 1 will be included in titles, right? Am I right? Section 2 will be the definitions. Usually, that is the we will see most of the acts. But here it is a different. If you see in a page, initial pages, title 1 gives the name and territory of the union. Article 1. Article 5, it is not citizenship related. Article 390, if you see. Most of the people gone through this question, I think so. But a little bit carefully. You have to search simply. So if you see 393, if you can see that's a short title. So that is the answer. So don't simply go to the this is a direct question. Fundamental rights part 3. You remember blindly fundamental. If you don't remember, you check that headings. That's what I'm insisting to check headings. Part 1 here. If you see in Constitutional Bear Act, Part 1 Union and its territories. Part 2 citizenship. Part 3 fundamental rights. So okay, part 4 DPSP, part 4A fundamental rules. This 3, 4, 4A is very important. From these two questions, 2 or 3 questions compulsory will come, which includes even 4 questions. We can say writs also includes writs if it comes. Okay, be careful. Fundamental rights part 3. So okay, by which of the following Amendment Act of 1985, anti-defection law? Anti-defection law, I told you where it will come. Anyone please tell me. Anti-defection law we discussed.
10th schedule, right?
Exactly. It comes in schedules, not in articles. Anti-defection law. Anti-defection law means MLA, MP elected from the one party, but he is jumping. MLA's MP is jumping case, jumping to the another party. Just you remember this one. So if you see 10th schedule in your book, that is in a provisions as to the disqualification on ground of defection. Okay, if you open that page, particular page 231, schedule 10, that amendment, anti-defection law, 52nd amendment, it will be written. You check it. Okay, just it is a practice. It is answer is very much there. Don't blindly pass it. Just check it as a practice. At least you open the book, your memory will be remembered. Okay, it's anti-defection law, schedules law. It doesn't come in articles. It just comes in. So there is only one clue. It is there. Constitution of India. Constitution of India means you have to open the Constitution of India Bare Act. But anti-defection law, it is direct. No, you can find out any word in this one. Defection you can find, but entire titles you read at the end it is there. But if you remember, then it is easy to go through. So in which of the following case the Supreme Court decided that constitutional amendment is a law within the meaning of Article 13 of 2, therefore it is violates any of the fundamental rights, it may be declared void. So it's in a question, case law question 13th. It is in a Golaknath case. So sequence you remember, Sajjan Singh, Golaknath case is overruled by Sajjan. After that one, Golaknath case, next Keshwanand Bharati. How, see in these questions, how we can take it out? First they asked within the amendment of Article 13 of 2. So first Keshavananda Bharati case, basic structure doctrine, that is the not answer. Okay, B is not answer. Indira Shahwani case is in a reservation case, that is a not answer. Then what is an A and D? A and D only it is there. So among that one you have to choose. Little tricky you have to do. Odd man out. This is this way you can do it. These questions. So that if you go through some case laws, you can do this way. Okay, this is a straightforward uniform civil code in India is uniform civil code. If you see Directive Principle part 2, part 4, 44, if you see section 44, 44, if you see uniform civil code is there. Uniform civil code for the citizens. Still they are struggling. So much fights are going on. Instead of customary laws for each religion separately, this uniform civil code. Even Sahara Bano case, Shabano case, this is came up. Uniform civil code, UCC, section 44. You see. So this is also one of the easiest question, confusing question. How? They are asking Article 16. You open Article 16. All answers are similar, but one of the answer is correct. But they mention religion, race. The second one also starts with religion, age. But third one, religion, race. Third one also religion, race. And the words here and there it is changed. you observe exact word matching should be there from your book. So you open article 16, the page number in your respective books. In my book, it is in a 5. So match with the answers. Which answer is there? Okay, if you see that article 16 subclass 2, no citizen shall on grounds only religion, race, caste, sex, descent, place of birth, resident. You match those words, each word by word there. You simply read it, and first 4 are matching. Suppose religion, race, caste, sex, 4 are matching. Then go with the check the answer. So this is also one of the confusion, and so we have to check properly. So if you miss one, then it's gone. So the minimum number of judges who are to be purpose of deciding the case involving substantial questions of the law. This is a straightforward. Then Article 143, you can go. You can mention or not. I can see just once again. This is a 5. Actually, even numbers never been there. Even numbers of 2, 4 won't be there. Actually, odd number judges only there. Even Keshavananda Bharati case, 13 members are there. 7 members, either 3 members, 2 members will be there. Very that case, what will happen when conflict will happen? One person yes, one person no will say, then again conflict will happen. It is there, very much there, but we have to know in which cases that will be followed. So if you see 143, so 143 is a power to president to consult Supreme Court. He can consult Supreme Court. This is a Berubari case actually. Now I remember a Berubari case. Then he appointed five members. 5 members. It is not given anywhere in the Bear Act. You can see the words also. It is not given anywhere. So you remember 5. Usually odd number will be there, not even number. This is also straight according to Article 300A. 300A many times. What is Amendment 40? A is a 44th Amendment. 44th Amendment 1971. If you see that open, no person shall be deprived. Dash, no dash shall be deprived. It's a straight question. No person. So this is the, in our group it is conflicting actually. Which of the following is not a law according to the Article 13 of the Constitution India? This is where it is came up UCC, Uniform Civil Code. So if you see Article 13, it is very much, it is included rules, bylaws, customer usage. Oh, it is not mentioned. It is not there. So none of this. Ani Prasad, agree? Actually, you are conflicting with this answer.
No, sir.
No, somebody told C is the answer.
Sir, actually, what I am saying is, sir, what is the purpose of Article 13?
Yeah, please explain just quickly. Let's see.
Article 13, judicial review, right?
Yeah, Article 13, judicial review. Exactly.
Question according to Article 13. They are asking. So, according to Article 13,
legal aid, right to fast legal aid. Whenever the question is comes up, this is under Article 21. Usseinara cartoon, Bihar. So actually, before that one, it is free legal aid option was not there for Indians. Means feel that when people, it is in a very costly. If you go to the courts and everything, it is in a costly. So after that one, Hussein Khatura is fight for the right to free legal aid under Article 21. You remember this one, free legal aid and fast legal services. Rule of law means same, equal before the law, supremacy law, predominance of legal spirit. Somewhere I read it actually. Can you